and locked the doors, and so there was no employee inside the Circle K. Someone came by and threw a cinder block through the front door, breaking it and allowing people to enter, and several people entered, and they were then told to leave. They did not, some of them did not leave immediately, and therefore that's why they were charged with this solicitation to commit burglary. Mr. Kimball was one of the people who did enter the store during that time.
All right, so Mr. Kimball, you've heard what your lawyer just said. Is all that true?
Yes.
So you went into the Circle K after the window was broken, and you went in there with the intent to steal something or take stuff? Any addition to the factual basis?
No, Your Honor. Thank you.
The court finds the plea is knowingly, intelligently, and voluntarily made. There's a factual basis for it. The plea is accepted, and entered on record. Is 30 days okay?
That's fine.
All right, it is ordered the probation department prepare a pre-sentence report. We can set sentencing for Mr. Ezra, I could do May 6, which is a little short of 30 days, or how about, let's see. May 8th?
May 8th looks better for me, Judge.
All right. So it's ordered setting this matter for sentencing on Wednesday, May 8th at 9 a.m. Before Division VE. I'm not sure who that will be on that day, so we'll find out who will be covering that day. But if you are in custody, but if somehow you're released from custody before your sentencing, you need to be here on May 8th. And if you're not here, I want to wish you your best, okay? Thank you. Mr. Ezzo, the clerk is telling me that there's a different petition to revoke probation pending. 2023 case?
Yeah,
Sure.
Oh, no, that's correct. I'm sorry, Judge, that is correct. And I had gone over that with Mr. Kimball. That's my error, I'm sorry. He was on probation. I did go over that with him when I talked to him last week and explained to him that an admission of the plea would trigger an automatic violation of his probation. I don't know if we called that case,
We
but,
didn't. I'll do it now. So,
he is aware of that.
all right.
I
So-
apologize.
Mr. Kimball, before I let you go, there was some confusion. Apparently, you are on probation for another case, but a petition to revoke that probation is pending. So I think maybe me and Mr. Ezzo confused you because about saying there was no petition. So you understand that by pleading guilty to this offense, that's a violation of your probation. Do you understand that?
Yeah.
How do you want to handle the probation? Do you want to, it is on the calendar today. It's, I'll call it now, it's CR 2023 0378, and it's on for a status conference on the petition to revoke.
So, Judge, since he did accept the plea, he's violated probation. I talked to Jeremy about that. He understands that. So I would ask the court simply to set the disposition hearing on that the same date as his sentencing.
Do you happen to have a copy of the petition with you?
I have not, I don't think I have seen it. I believe it was a 6.
I've got it up here on my computer. I can bring it up if you want to see it. It's 2 6s.
Is it 2 6?
2 6s. Both of them are identically named as of now.
Can I borrow
Yeah.
your copy? Thank you. All right, so Mr. Kimball, on CR 2023-0378, there is a petition pending before the court to revoke your probation. And I don't know, Mr. Ezzo, how you all normally handle this, but the underlying offense that he just pled guilty to is not alleged as a violation. So, Mr. Gant, how do you just want to
I think typically it's just an automatic violation if somebody pleads.
Okay.
So you can just advise him of the potential consequences of a couple of sixes.
Okay, all right. So, Mr. Kimball, because, do you agree, Mr. Evans?
Yes, Judge.
Because you pled guilty to another offense and you're on probation, that's kind of an automatic, or not kind of, it is an automatic violation of your probation. You're on probation right now for two Class 6 undesignated offenses. So those two offenses, just like the one you just pled to, they carry potential prison ranges of 0.33 years to 2 years with presumptives of 1 year. You could also be continued on probation on those two offenses. And probation, as you know, can be up to 3 years on Class 6. The difference between these two offenses and the one you just pled guilty to is these are undesignated, which means the court could, designate the offenses misdemeanors if you were to ever successfully complete probation. You have to understand, if I plead guilty to the last offense, the court could simply designate these two as felonies as well at your upcoming disposition hearing. Do you understand all that?
Yeah.
And, we kind of want to make sure, even knowing now these consequences of violating your probation, are you still comfortable with having pled guilty in the other case?
Everything is the same as what we have. Yes.
All right. So the court does find that the defendant is in violation of his probation and it's ordered setting the matter for disposition on Wednesday, May 8th at 9 a.m. before Division B.
Thank you, Judge.
Sorry about that.
No, thank you, that was my mistake.
It's further ordered vacating the pretrial conference set for set for May 8th, and instead we'll have the sentencing disposition on that date.
Thank you, Judge. Thanks,
All
Brian.
Good morning, Your Honor. I'm Mrs. Johnson.
Okay.
And we have a plea if I may approach.
Sure. Go ahead. All right. This is State of Arizona versus Melody Johnson, CR 2023-3017. Will counsel announce their appearances, please?
Victoria Otto for the state. Good morning, Judge. Mr. Robbie Johnson, who's the victim in the case, is present in the court, and the Navy poet.
Good morning, Your Honor. Antea Gadalitza on behalf of myself and Samuel Diffenderfer, who is not present today, for Melody Johnson, who is in custody and present today.
All right. Good morning, Ms. Johnson. If you were, I don't know if you were in here when I introduced myself to the last defendant. I'm Judge Johnson. I'm covering this division because Judge Godoy retired. So I've been handed a plea agreement. Is that what you'd like to do today?
Yes, ma'am.
Right, and I know you saw the tail end at least of the plea that we just did, so I have the same kind of questions for you. I'll be asking you those questions, and if at any time you need to consult with your lawyer, just let me know, okay?
Okay.
Right, so can you tell me your true name and your date of birth, please?
Your Honor, my name is Melody Tolecano Johnson.
And what's your date of birth?
March 30, 1984.
Do you read and understand English?
Yes, ma'am.
How far did you go in school?
Third year college.
Have you had any drugs, alcohol, or medication in the last 24 hours?
No, ma'am.
I need to advise you, as I advise everyone, that if you are not a U.S. citizen, pleading guilty or no contest may affect your immigration status, resulting in you being deported or removed, prevent you from ever obtaining legal status or becoming a U.S. citizen, even if charges are later dismissed. All right, so Ms. Johnson, the plea agreement that I've been handed indicates that you are considering pleading guilty today to amended count 2 and amended count 3. Both of those are adding poison or harmful substance to food or drink, which is a class 6 designated felony. Is that your understanding of what you're here to do today?
Yes, ma'am.
Under this plea agreement, there is a possibility that you would be sentenced to prison. If you are sentenced to prison, the prison range could be anywhere from a mitigated sentence of 0.33 years to an aggravated sentence of 2 years with a presumptive sentence of 1 year. Do you understand that?
Yes, ma'am.
If you are sentenced to prison by the judge that sentences you, you must serve approximately 85% of the sentence imposed before you would be released on any basis. If you're released, you'd be released to community supervision, which is basically supervision for 1 day of every 7 days that you spend in custody. Do you understand that?
Yes.
Under this plea agreement, you could also potentially be fined up to $150,000 with a surcharge. You understand that? Now, the plea agreement also gives the judge that sentences you the option of putting you on probation. So it's what we call probation available. That means that probation is not guaranteed, but that the court could choose to put you on probation. And if the court placed you on probation, you could be placed on probation for up to 3 years on each of these counts. Do you understand that? Now, there's a couple special terms in the plea, and what they indicate is that if you're sentenced to prison on both of the counts, the terms imposed shall run consecutively to one another. So what consecutive means is one after the other. So if the court sentenced you to prison, say for the presumptive term of 1 year on each count, those would be 1 year plus 1 year. Do you understand that? The other special term indicates that if the court puts you on probation on one count and sentences you to prison on one count, that the probation would have to run consecutive to the prison term. Do you understand that? There's also a special term that says if the court imposes probation on either or both of the counts, that the initial term of probation can't be less than 3 years. So do you understand that?
Yes, ma'am.
And you're further agreeing that if you're placed on probation, that you will not petition the court for early termination of that probation until you've completed at least 18 months of probation. You understand that?
Yes.
All right. Has anyone threatened you or promised you anything other than what's contained in this plea agreement?
No.
And are you on probation or parole right now?
No.
And it looks to me like on the second to last page of the plea agreement, there's a line with your name on it and the signature. Did you sign this plea?
Yes.
And did you read it before you signed it?
Yes, ma'am.
And do you feel like you've had enough time going over it with your attorney and you feel comfortable that you understand its contents? Right. Now, if you take the plea, Ms. Johnson, you are giving up certain constitutional rights. Those constitutional rights include keeping your plea of not guilty and having a trial by jury. If we have that trial by jury, your attorney would continue to represent you at little or no cost to you. And at the trial, you would be able to confront and cross-examine the witnesses that the state calls against you. And you could call your own witnesses and have them ordered to appear by way of subpoena if you decided that was appropriate. You'd also have the right to testify at that trial or not. It would be up to you. You could keep your right to remain silent. And you'd be presumed innocent until proven guilty by beyond a reasonable doubt. Do you understand all that?
Yes, ma'am.
And obviously, if you plead guilty, we're not going to have the trial because in a minute, I'll ask you if you plead and you'll have to tell me what you did, okay? There's also, in this plea agreement, you're giving up your right to have a jury trial on aggravating factors. And what that means is basically, if the court did want to send you to prison and send you to prison for more than a year, The court can't do that unless there's some kind of finding of an aggravating factor. And you have the right to have the jury find those factors. But under this plea agreement, you're waiving that right and letting the court decide what the aggravating factors are on its own. Do you understand that?
Yes.
And finally, by entering a plea agreement, you would give up your right to direct appeal, and your only avenue of relief would be to file a petition for post-conviction relief with the judge that sentences you. Do you understand that? Having heard about all of your rights, are you willing to waive your rights and plead guilty today?
Yes, ma'am.
Do you understand your rights?
Yes.
All right, so let's talk about the two charges. They're amended count 1 and amended count 2, both adding poison or harmful substance to food or drink, a class 6 designated felony. Let's start with amended count 2. It indicates that on or about July 11th, that you intended to harm, is it Robbie Johnson, by adding or mingling poison or chemical compound to water, food, or drink. How do you plead, guilty or not guilty?
Guilty.
Right, then amended count 3, is the same count, and this alleges that on July 18th of 2023, you intended to harm Robbie Johnson by introducing, adding, or mingling poison or chemical compound to his water, food, drink, or medicine. How do you plead, guilty or not guilty?
Guilty.
How do you want to do the factual basis? Does counsel want to do it, or do you want me to ask Ms. Johnson?
I can do it, that's
Sure,
fine.
go ahead.
Sure. As to amended count 2 on July 11th, Melody intended to harm Robbie by introducing a trace amount of bleach, which is a chemical compound, into the water reservoir of his coffee maker, which Robbie then later intended to drink. And that happened here in Pima County, excuse me. And as to count 3, the same thing happened on July 18th here in Pima County.
Ms. Johnson, you just heard what your attorney told me. Are those things true?
Yes, ma'am.
So you did those things? Is that yes?
Yes, ma'am.
State satisfied with factual basis?
Yes, Judge.
The court finds that the plea is knowingly, intelligently, and voluntarily made. A factual basis exists for it. The plea is accepted and entered of record. Is 30 days okay for sentencing?
Yes, Judge.
Your Honor, that should work for me, and I spoke with Mrs. Otto. I do not believe that we can appear in the Division BE in 30 days, given the changes. We have stipulated to a sentencing in front of Judge Sean Lopez, if that's
Is that true?
Yes, Judge.
All right. Does he know that? Is he okay with it?
He does not know that, but we'll verify before the sentencing actually occurs.
All right. Check his. I'm not sure. Does anybody know what his start date is?
I can tell you that momentarily, Judge.
Thank you. My agave is not working.
I will say, I don't think it's a Friday. We could aim for May 10th.
It isn't a Friday, because that's when I have coverage.
Okay. Oh, so does that mean that would work for you? or-
That would work perfectly, because I'll
Oh,
already
you're
be there.
covered in there. All right. And you're okay to waive the 2
Yes,
days?
sure.
All right. It is ordered it's ordered that the probation department prepare a pre-sentence report. It is ordered the matters be set for sentencing on Friday, May 10th at 9 a.m. before Division 15, Judge Sean Lopez. Ms. Johnson, obviously you're in custody, but if for some reason you're released, you need to be back in court before Judge Sean Lopez on Friday, May 10th. If not, a warrant could issue for your arrest, okay?
Okay.
Anything else, counsel?
Okay, Judge.
No. And then, are there further hearings we need to vacate or something?
I don't believe so.
All right, George, tell me now. Thank you. Anything else for anyone?
Yep.